All right, good morning, everyone. This is JJ Risha with Pismo Ventures. And today we have two great attorneys from Kenobi Martins, just like we had one webinar from last week from Bruce and Greg from Kenobi. Today is a little bit different subject. It's really the roadmap for IP protection for startups. Rabi, Narula, and Damien Howard will be talking in a couple of minutes. I'll let them introduce themselves, and also we'll let them, give them the floor to talk about the webinar today. Just a short recap about what we're doing, what have been happening with the competition. We started round one yesterday, and so we will have the startups that will emerge out of round one will be announced on October 9th. So right now, all the judges, investors are evaluating the competition submissions. So we will have all that hopefully ready by the October 8th, and we'll make an announcement to everybody as to who's moving to round two by October 9th. What I would suggest is for everyone to be prepared for a 5-minute pitch and 5-minute Q&A for round two. And if you make it to round three, which is the final round, you'd be doing 12-minute pitch and 12-minute Q&A. So for now, just be prepared and stay tuned to do that. So we have another webinar tomorrow, and then we have webinars next week. So we will have webinars every week until the end of the competition. That way we're providing you with a lot of educational experiences and knowledge in order to learn about really everything startup. The other thing that I was going to talk about is that we, after every, right now, by the ones that have been attending the webinars, after every webinar, there is a virtual networking time, and usually starts around 10 or whenever the webinar is done. And we will put the link for the networking in the chat. And there is a password, so you need both. You need the link and the password in order for you to go into the networking section. That's it for me. If you have any questions, you can always email me or email Stephen, and we'll be able to help you. Rabi and Damien, thank you for being here today. We'll look forward to hearing all about the roadmap. Please introduce yourselves quickly, and then you can take it from there.
Great. Okay. Good morning, afternoon, or evening, depending on your time zone. My name is Rabi Narula. I'm a partner at Kenobi Martins. I've been practicing law or intellectual property law for over 21 years now. I have a background in mechanical engineering, my undergrad and master's degree, and many of my clients are venture capital-backed startup companies, individual-backed startup companies, or even large companies in the medical device space, robotics, consumer product space. I'll be presenting with Damien Howard, who I'll let introduce himself now.
Thank you, Rabi. So I've been practicing for over 10 years now. I'm also a partner at Kenobi Martins. I have a technical background in electrical engineering and computer science, as well as some pre-law work experience in the telecom industry. I help large clients and small clients of all sizes in a variety of technology areas. But primarily, I help clients in telecom hardware, computer hardware, as well as software such as video games and machine learning, and some medical device work as well.
And so our topic today is, as you can see from the title slide here, Startup Your IP, a roadmap to IP protection for startups. And what we're going to try to do is really kind of give you a kind of IP 101 from a startup's point of view, what's important, what's available for you to get protection on, and some of the costs associated with these items, and some of the pitfalls and things you should be watching out for very early in the startup. I think, like a lot of things, if you do things right at the beginning, you avoid problems and costs later down. It's a lot easier to fix things up front than later on. I think that applies to a lot of issues with startups. So, and as JJ mentioned, feel free to type in some questions, and we'll try to address those questions as we go through this. So our goal, as I mentioned, is to provide you with a kind of high level basic knowledge of the type of what IP is and what you can get as a startup. Why it can be important, and also when, the times when you really should be looking for an attorney for help. There's no way that in this presentation I can make you an IP lawyer. IP law is one of the more complex areas of law, and it would, could take years to really come up to speed. But the key is so that you can issue spot and know when to talk to an attorney. Some themes that you're going to see through this presentation is, again, this idea of identifying IP. There are different types of IP. They have different purposes. There are different ways to obtain them, and they have different values. So I want you to, kind of keep track of that as we go through the presentation. For each of these different types of IP, there's different ways to protect them and different ways to maintain them. And the other thing to always keep in mind on is most startups are thinking about being acquired at one stage or getting some type of investment. So you have to have an eye on due diligence. And doing due diligence, any investor is going to ask 3 basic questions. Do you own your IP? What does your IP protect? And are you violating somebody else's IP? So keep those kind of issues in the background as we go through these slides. So with that, I think I'm going to turn it over to Damien, just give us all on the same page and give a high-level overview of the different types of IP.
Thanks, Robbie. Yes, so there are 4 types of intellectual property. The one that people may be most familiar with are patents. And patents give you a right to exclude others from making, using, selling, or bringing into the country your invention. Your invention can be almost any type of useful process, like a method of doing something, a machine, actual device that you make, method of manufacturing your device, or a composition of matter. And there are several types of patents. The one that you might think of most often, what I might say is a regular patent, or what we call a utility patent, covers your inventive idea. And that gives you 20 years of protection to exclude others. And that's really the most important aspect about patents. It's the right to exclude. Often people who aren't familiar with patents think that having a patent means that you have the right to make something, and that's not necessarily the case. It just gives you the right to stop other people from making, using, selling, or importing your invention. So in addition to the utility patent, you might often hear from an attorney that there's something called a provisional patent. And provisional patent is a very useful tool. So in the US and in most countries, the person who gets the patent is the first inventor to file. What the provisional patent allows you to do is to file early, possibly before you've even finished developing your invention. When you file the provisional patent, it doesn't become a regular patent, but it does give you a year to continue working on your product before you file the regular patent, and prevents someone else from filing before you. So in addition to the utility and provisional patent, there's also something called a design patent, which allows you to protect the unique look and feel of your product rather than its functionality. In addition to patents, there are trademarks, which let you prevent others from using marks that are likely to confuse your customers or consumers. It's essentially what you would use to protect your brand or your marketing. Copyrights, which let you prevent others from the unauthorized copying or distribution of original authorship works. This is usually books, music, movies, but it's not limited to just that. Copyrights can be useful for stopping others from copying your instruction guides, manuals, websites, or anywhere where you might print content. You can also use copyrights to protect your software source code. So these 3 types of intellectual property are all types of intellectual property that you can file for or register with the government, federal government. But a 4th type, which is also important and shouldn't be overlooked, is trade secrets. Trade secrets is essentially maintaining your invention or intellectual property as a secret, and it lets you protect this proprietary information. The key with trade secrets is to make sure that you actually develop a way to protect them and that you follow that process. So for example, restricting the number of people who have access to your secret. If you let anyone come into or out of your business and see your secrets, it's hard to call it a trade secret, and it's hard for you to enforce an action against someone who's taken your trade secret. So another way to think of intellectual property is the type of concepts that you can protect. So you can protect your ideas using two different types of intellectual property: the patents, which allow you to exclude others from using your ideas, or the trade secret that lets you basically not reveal your invention. So think of Coca-Cola. Formula for Coca-Cola is a trade secret. You can protect the expressions of your intellectual property using design patents, look and feel, or copyright, how you put it down on paper or on a website. And lastly, to protect your brand name, you'd use trademarks.
Thanks, Aaron. So now that we've kind of given you a little bit of a high-level overview of the different types of IP that your company may be developing, just going to dig a little deeper, give you a little bit more information about each of these areas and things you need to watch out for. So as Damien mentioned, copyrights. The goal is to protect creative works, images, code, text. And what's interesting about copyrights is just like kind of the name. It's a right to prevent other people from copying. It's kind of right there in the title. And it also maybe controls how people might use your copyrighted work. The cost of obtaining a copyright is very low or perhaps even zero. That is, you have a copyright in something you create as soon as you reduce it to a tangible medium. So you put it on your computer, you write it down. As soon as you do that, you have a copyright. However, people often talk about a registered copyright. And to do that, you do need to go through a step where you send something to the federal government and register your copyright. That is still very low, certainly only on the order of hundreds of dollars to obtain a registered copyright. So when would you need an attorney? This is an area where certain people do register copyrights themselves once they've had practice or once they've worked with an attorney a few times on it. But I still recommend getting an attorney, particularly if you've never filed a copyright before or registered a copyright before. It is important if you ever think somebody's infringing your copyright to have an attorney involved, because there are certain steps you're going to want to take there in terms of enforcement. In addition, there are advantages to registering your copyright because you can get enhanced damages or statutory damages when there is infringement. So if you suspect infringement, there may be an extra incentive to have your copyright registered. And as this bullet point says, if you are actually distributing things on the web, for example, software is a classic. Once you start distributing software, that's another instance where registering your copyright before you start distributing is important. So some key takeaways for startups. For many startups, it depends on the industry, but certainly maybe in the software industry, copyrights may be your most important IP right. Certainly if you're in the entertainment industry, copyrights are often your most important IP right. It's the easiest and cheapest to obtain. I think it's important to keep track of it. The last bullet point there, know when you're using others' copyrights and the ramification. I do see startups trip up on this in a couple of ways. For example, it is very easy for you to use somebody else's copyrighted materials. I've seen many situations where engineers or software developers or website developers think that anything on the internet is freely copied, that you can copy it, that is free to use. And so it's very common for startups to take somebody else's copyrighted work and start to integrate it into their material very early on in the process. And that can cause problems later on. There are copyright trolls out there that look for companies that have taken their copyrighted images, pictures, and will send cease and desist letters if they see that you're using their copyrighted materials inappropriately. Damien, I think you want to talk a little bit about open source too.
Yeah, thanks, Rabi. And so, I mean, precisely what you were just saying, you gotta have to be careful what your developers are using. I mean, that applies for open source as well. There's many different open source licenses out there. Some of them are very restrictive. And if you want to be able to maintain your software as a proprietary product and keep control over it, you want to be careful about what open source what open source software you're using and the licenses it has. And sometimes, although it may be more expensive and more time consuming to develop the software yourself, in the long run, that may be preferred over open source. There are certainly some open source licenses that are more permissive. For example, the Apache license and the MIT license are fairly permissive, but the GPL license can be very restrictive. And the open source licenses, some of them can be infectious. So even if you think that you're only using one particular library or it's only being used in one part of your software code, it could end up leaving all of your software open to the open source license and restrict you from maintaining it as proprietary code. And you also want to be careful that there aren't some buried licenses within the open source software. You may think that you found some library that you want to use that appears to have a very permissive license, but the person who created that license may have not looked carefully through open source software that he or she was using, and it may turn out that there may actually be a restrictive license. So just always be careful when taking software from the internet.
Yeah, and in my experience, I think a good way for a startup to kind of, at the very beginning, start doing things the right way is maybe having a group meeting periodically where you review these issues and what the company's policies is with respect to open source, with respect to being conscious about not using other people's copyrighted materials, and maybe having an engineering 101 course or developers course to periodically remind your team about these issues early on, I think will go a long way to preventing problems later on in the process. Okay, now we're going to turn to trade secrets, David. Oh,
Trademarks.
Sorry, trademarks.
So as I mentioned earlier, trademarks are used to protect your brand. They can be used for brand names, logos, slogans. And what they do is they give you the ability to prevent someone from using your trademark or anything that's confusingly similar. So for example, if I wanted to open my own computing company, I might call it Damien's Computers, assuming that there's nothing out there that's confusingly similar, I could get a trademark on it. Now, someone else might decide to start their own computing company, maybe called Damon's Computers. Arguably same name, different names, spelling's a little bit different, but it's likely that consumers could confuse our two companies. So that's why you'd want to register a trademark so that you can prevent others from coming up with anything that's confusingly similar. And it's important in order to maintain your trademark that you enforce it. If I allow Damon's Computers to continue operating, it's possible that I could lose my trademark or lose the benefit of it. Trademarks are great because they're relatively low cost and relatively easy to obtain. And in fact, you could actually file for a trademark yourself. However, there are certainly times where you'd want to consider an attorney. For example, if you're considering branching out into other product spaces, or if you haven't yet thought about other product spaces, it's great to get an attorney because they can help you craft the description of your product or service in a way that can cover not just the products that you are considering releasing now, but any tangential products that you may want to later produce or sell with your brand. Sometimes you don't think of certain products. For example, going back to my computing example, maybe I want to start selling t-shirts that have my brand name on it. So there are different categories that you'd want to register your trademark under depending on the different products that you want to protect. So it's important to accurately craft the description of the products or services that you want to file your trademark under. And it's also useful to get an attorney involved if your trademark might be similar to something else, something that would be difficult to register. As an attorney can help you craft arguments as to why you should obtain your trademark over something that the Patent and Trademark Office might consider to be similar. So the trademark, like I said, it gives you the ability to build a strong brand. But in order to do that, you want to make sure that you are protecting your trademark. That means that you want to continue to monitor your trademark, make sure that there aren't others that are using it or using something similar, and you want to enforce it. So that often can lead to legal fees, but if you don't protect your trademark, if you don't bring suit, it's possible that you could lose your trademark, or the trademark could become a generic term, and then you would lose essentially the ability to enforce the trademark. Anyone can use it. So I think now Rabi is going to talk about trade secrets.
Yeah, just a couple final comments on trademarks, though. Just, this is I think Damien mentioned it, but an important place to do searching, I think, before you get going. I mean, the last thing you want to do is launch a trademark, invest a lot of money into marketing, and then find out that you're very close to somebody else's trademark. It's going to set you back. I think any sort of person knows that branding is very important. You want to build a brand, and having to switch brands midstream is not a good place to be. It's also a place to maybe look globally in terms of your searching, because what is good for the US may not be good in another jurisdiction. And there may be different conflicts in different jurisdictions. It may look good in the US, but not good in another country. And so just, again, I think these are one of the more important items to kind of do searching up front to make sure that you don't have issues down the road. One other thing is there's always a tension in trademarks between, in my view, what often marketing people want is a very descriptive mark that describes your services, and a very unique mark that is a stronger trademark. On the last slide, Apple. Apple is an example of a trademark. It's in the context of computers, it's a very unique mark. It doesn't describe the services, but oftentimes people want trademarks that actually describe the services, and that is not considered a strong trademark, and it may be difficult for you to actually get that trademark because the Patent and Trademark Office may object to it as being descriptive. Okay, so I'm going to talk a little bit about trade secrets. We kind of mentioned this. Trade secrets are basically any information that your company has that has commercial value or provides you with a competitive advantage, so long as you keep it a secret. And that's the key. Unfortunately, with trade secrets, once it gets out there and into the public domain, the cat's out of the bag. There's nothing you can do to kind of get it back in. You could maybe sue the person who stole it from you, but once it's out in the public domain, there's very little you can do about it. So that's why when it's the third bullet point there says rights given almost none, it's not quite none. You can still sue somebody from taking it from you and maybe prevent somebody from taking the trade secret from you. But once it gets out there onto the internet, it's going to be out there. David mentioned the Coca-Cola example. It's a secret and it's valuable as long as it remains a secret. But if it ever got out into the public, it would lose its value very quickly. You don't need to register your trade secrets. The way you get a trade secret is by keeping it confidential. So you have passwords on your computer. You don't let people copy it onto hard drives and take it away from your company. You mark things confidential. Those are the internal steps you take to preserve your trade secrets. So in terms of having an attorney, I think maybe you might have an attorney early on just providing you some general advice about the type of procedures you should have to keep your trade secrets a secret. Certainly if you're ever talking with any third parties, you would want to have an attorney involved. this is also where you would want to have agreements in place, like a NDA, a non-disclosure agreement, or sometimes people call it a CDA, a confidential disclosure agreement. You have those agreements in place to preserve your trade secrets when you need to disclose things to third parties. And certainly if you think somebody has stolen your trade secret, like a competitor or a former employee or consultant, that's another time where you want to involve an attorney very early on in the process. So some key takeaways: trade secrets are the default protection of information as long as you're keeping it secret. They're very important. Oftentimes a company's most valuable IP is the trade secret. You need to have your agreements in place and internal procedures. That's your first line of protection. And the last bullet point there about be aware when you might be using other trade secrets. And what I mean by that is trade secret litigation is probably the fastest growing area of IP litigation. It is so easy for an employee or a consultant or somebody who worked at your company to steal trade secrets now. All you need is a thumb drive or something like that, and you can just download tons of information very quickly. And that is happening more often now, and so you're seeing more trade secret litigation. So I think you also need to be careful about people you're hiring. Are they bringing trade secrets with them inappropriately? And are you taking steps to remind them that you don't want any third-party trade secrets used in your company? I think that's an important thing to watch out for, bringing on new employees.
Yeah, that's right, Robbie. And the key thing with trade secrets is that you keep it a secret, which is not always possible, right? And so that's what leads us to patents. Sometimes as soon as your product is out there, someone's going to be able to reverse engineer it and determine what is your secret sauce. And so trade secrets are only good for certain types of products, certain types of important information. But for inventions that someone could reverse engineer or something that could easily leave the company, that's when you want to consider patents. And with a patent, you have to disclose exactly what you're doing and how to do it. So, oftentimes people are hesitant to do that because they're afraid of competitors using it. But if they're going to be able to discover what you're doing anyway, then at least with the patent, you can get some protection. You can get up to 20 years to stop other people from using your invention. And so an invention is a technical achievement over whatever's come before. It's basically an improvement. And as we've mentioned a few times throughout this presentation, what it gives you is the ability to stop others from using your invention. And the costs can be relatively high, and they can be difficult to obtain sometimes. And so sometimes that scares people off, but the benefits are worth it in most cases, particularly when it's not possible to keep your invention a secret. So when you need an attorney, you almost always want an attorney when it comes to patents. Patents are very complicated. The law is very complicated. There's a whole second bar exam beyond the regular bar exam that attorneys take, that they need to take to be a patent attorney. And the law's always changing. And there's, it can be very hard to read a patent and very hard to craft the language in a way that truly covers or protects what you want to protect. And so we would always recommend getting an attorney when you're filing a patent. Robbie, are there any other times? I mean,
no. Oh, sorry, go ahead. You can ask if I had more comments, but go ahead. Sorry.
I was just going to ask, other reasons you'd think that you want an attorney when you, when you want to file a patent.
Yeah, I think, as you mentioned, I think patents, almost every single, the only time I've seen people not use an attorney is maybe for a provisional application. And we'll talk a little bit more about the proper use of a provisional application a little later. I see there's some questions about that. But that's an area where if there's going to be no disclosure, you're just very early on in the process, I could see some people filing a provisional if you're experienced with patent applications. But even then, I would recommend that you give the patent attorney an hour or so to make sure there's nothing that could hurt you in your provisional application. You can certainly have a very light touch on a provisional in certain circumstances to save money.
Right. Yeah. And so, as we've said, patents are important for building a fence around your technical advancement, your improvement. Sometimes people think once you've filed a patent that you're good to go, you can stop anyone from doing anything. And that is true to some point, but there are often multiple ways to create a product or to perform a process. And so it's important to not just file one patent, but to build a thicket or a fence around your innovations by, filing patents for alternative embodiments. Every time you think of an improvement, file another patent to protect the improvement. The more patents you have, the more likely it is that you're going to be able to stop someone else from copying your product. Oftentimes, if you have a single patent, someone can find a way to build around your patent. But if, as you're developing, you continue to file on those new ideas, file additional patents, it makes it harder and harder for someone to design around your product. But at the same time, you don't want to rely on just patents. You want to think of it as just one asset in a diversified portfolio. You want to consider, aspects of your invention may be still worthy of a trade secret. It may be that there are certain portions that cannot be reverse engineered. Underlying, firmware may be hard to discover if someone is infringing it. If it's hard to discover if someone's infringing, it may not be worth the expense of filing the patent. So you want to balance between when you want to file a patent and when you want to have a trade secret. Similar, you want to think about your brand. If everyone associates the product with you, you want to have strong branding, and so you want to have trademarks as well. So, patents are useful, but you don't want to make that the end-all be-all. And some industries value patents more. In the software industry, patents can have value, but sometimes they're not valued as highly as in the medical device industry, for example.
Or biotech is another classic place.
And so, Rabi, what exactly is the timing on filing patents?
Yeah, and I'm going to go into that in the next slide here. But before I do, I thought there was a couple questions in the chat that I thought I'd just hit break. I think it's a good place to answer some of those. One of the questions was, how strong is putting a disclaimer at the bottom saying it is confidential propriety? Is it enforceable in the courts? I think it depends. The context matters there. Stamping, and I've seen this, stamping something confidential and then placing it on the internet is not going to carry a lot of weight in the court. So what I think it matters is, what is the context? How are you treating it? And in that confidential. So the stamp doesn't matter. It's part of how you treat something, but it has to be part of a larger context. So if you stamp something confidential and you have a non-disclosure agreement with a consultant, and before you give that information to your consultant, you also stamp it confidential, I think and then that consultant misuses that confidential information, that is a situation where you may have a violation of trade secrets. So just stamping it isn't enough in certain circumstances. It's the context of the legal relationship that you're disclosing information to somebody. But I certainly think that if you do believe it's confidential and it's an internal document, stamping it is also warning to your employees not to treat something in a haphazardly manner. So I hope I answered that question. And then now we'll get into some of the timing issues. There's some questions about when you convert a provisional application, and that will come up in some of the later slides. So, patent filing deadlines. It is very important that you realize that for patents, there are deadlines for filing a patent application. If you miss these deadlines, you cannot file a patent application, and you won't be able to obtain patent protection for your invention. The general rules are For the US, there's a limited grace period from the first public disclosure of sale made by you and only you, or somebody that got the information from you. And if you file within that 1-year grace period of your first public disclosure of sale, you can still file a patent application in the United States. So it's a limited grace period for your own disclosures. However, for most of the rest of the world, you must file your patent application before any public disclosure. Europe and China are 2 examples of regions where if you disclose your invention, it is too late for you, and you haven't filed a patent application yet, it is too late. You will be able to get protection in Europe and China in those circumstances. The other thing I wanted to kind of give you is a kind of typical maybe patent filing and cost timeline that a startup would go through. So it's not uncommon for somebody to, you first have a conception of the invention, and maybe you meet with your patent attorney. And at that point, you might file a provisional patent application. Now, my assumption here in using provisional patent application is that there hasn't been any public disclosure yet. You may be using the provisional patent application as a quick way to file something a little faster, a little cheaper to secure an early filing date, but you also know that you are not disclosing the invention yet, and that's important. If you were about to disclose the invention, I would make sure you had a regular patent application filed, or at least a provisional application that had all the contents of a regular application on file. At that point, you may then do a patent search. And then within 1 year of filing a provisional application, that's the deadline for filing a non-provisional application and for filing for foreign patent protection. And that is usually the form of a PCT application. And that's important because it's important to realize that in the United States, or all countries, you have to get a patent region by region or country by country. That is, a US patent only protects your invention in the United States. Eventually, if you want to get patent protection in other countries, you will have to file in those other countries. You typically do that by filing a PCT application, and then that allows you within 18 months to delay the cost and enter later in other jurisdictions like China, Europe, Japan, Korea. A few other things on this chart is just filing a patent application isn't the end of it. You don't have a patent yet. You have to go through an examination process where an examiner at the US Patent Office will review your application and decide whether or not your invention is new and non-obvious. And that can take 2 to 3 years to go through that process, and will cost money each time you have arguments back and forth with the examiners.
And so, like Robbie mentioned, a lot of times if you want to consider filing internationally, you might start with a PCT. However, there are some places where you need to file directly into the country and the PCT can't be used. For example, Taiwan is not a member of the PCT, and if you're considering filing in Taiwan, you need to file that at the same time that you're filing the non-provisional patent application. Oh, go ahead, Robbie.
Yeah, and so we put some dollar signs in here. So I wanted to give some rough ranges so you can get kind of an idea of what provisional. So provisional application, could be on the order, if you did most of the work and are familiar with filing a patent application and ask an attorney to give it a quick review, could be on the order of $1,000 to file. It can also be more expensive if you want your attorney to really add a lot, dig into it more and add maybe claims and a more detailed description. And it can cost anywhere between $8,000, $10,000, $15,000, $25,000, depending on the complexity of the invention. You can do a patent search on the order of $500 to $1,500, and you can get a pretty standard patent search done for most inventions. The filing fees in the United States for a patent application are in the order of $1,000. But when you file in Europe and China or Japan, for example, the filing fees are often much higher, more in the order of $6,000, $7,000, $8,000, or $9,000. So that gives you an idea of the difference between the costs associated with filing in the US and in foreign cases. And then the filing fees for a PCT application are on the order of $2,000 to $5,000, depending on some of the choices that you make.
Yeah, and like Robbie mentioned, you want to get an attorney involved early when you're filing a patent, preferably before you're filing the provisional. However, I understand that attorneys can be expensive, and oftentimes startups and individuals decide to file the provisional patent application themselves and then maybe go to an attorney to file the regular application. So I would suggest that you reach out to an attorney at least 3 to 4 months before the regular application has to be filed, as it can take quite a bit of back and forth and a lot of time to really well craft your non-provisional patent application.
Yeah, and I think the other thing, I keep mentioning these public disclosures. If you're coming to a patent attorney a day or two before a trade show where you're going to launch your product, won't give the attorney enough time to really draft the kind of adequate disclosure that we would like to see before a public disclosure. So again, I would use that 3 to 4 month kind of time frame to also apply before any launch of a product, or maybe you haven't filed a patent application. You should contact your attorney several months before that to give them time to draft up a proper patent application.
And getting your patent application examined is a lengthy process. It can take 2 to 3 years, sometimes even much longer, 4 or 5 years. And I know in some technology areas, such as software, in 4 to 5 years, the patent may not have as much value because things are changing so quickly. And so one way to accelerate that process is by filing what we call a track 1 application, or an accelerated examination. And essentially, this is paying the patent office to jump the line, to look at your application sooner. And this is a lot more expensive than the normal filing fees, but in actuality, the track 1 application tends to be cheaper in most cases in the long run, because you tend to get examiners who are a little bit better, or who do a little bit better of a search. They don't usually give these track 1 applications to new or junior examiners. And so the result of that is usually less back and forth time between the attorney and the examiner negotiating the exact scope of your claims. And so with a little bit more upfront cost, you tend to get the patent much faster, usually better claims, and actually cheaper in the long run. And so we often recommend filing track 1 applications, especially for startups who are, want to get their patent quickly for investment purposes, or to show that their invention is actually novel.
So, as I mentioned before, just to reiterate the point, patent protection is a country-by-country kind of exercise. And so, United States, luckily, we live in the biggest market and in the place where it's easiest to enforce patents. So, most companies are going to want to file in the United States. Europe actually has a European patent system. So, with one European patent application, you can cover most of Europe. You do have to individually validate in countries as you get further, and individually enforce right now. There is talks about having a more uniform European patent enforcement system, but there is some synergy in Europe right now. And those, frankly, in my practice, 80% of the time, that's the patent strategy. The United States and Europe, because those are the two largest markets. And in Europe, it's more, you can enforce patents in Europe, and it happens all the time. Other places that people file patents often are Canada and Australia, because they're English-speaking countries, and so there's not a lot of translation costs there. And so the cost of filing in Canada and Australia are not large, even though the markets aren't that large either. Certainly Japan and Korea are the next kind of list of places that people file. And then finally, China. People do file patents in China. There's a question about whether or not you can really get a patent in China. I've been practicing for 21 years. When I first started practice, people thought it was impossible to enforce a patent in China. And then, I think the trend is every year there's more and more examples of, patents being, enforced in China. That's the trend. It's still not as easy as in the United States. It's probably a home court advantage for Chinese companies in China, but I have seen instances in my practice where a Chinese patent has been used to, prevent a knockoff in China. It's also very useful sometimes if you're manufacturing the product in China. It is you'll see companies often file patents in China to give them another leverage against potentially their manufacturer if the manufacturer tries to, go in a different direction.
And a patent in China can also be useful if you're asserting it against a company that's not a Chinese company or a Chinese brand. If both companies are from outside China, then you may be on even footing.
So to kind of conclude, some common issues with IPs for startups are that, IP protects what you built. These are rights to exclude. They keep people from copying things that you created and creating counterfeit products or stealing your code or copying your technical advancements. As Damien mentioned, it's a right to exclude, but it's not a right to do something. It doesn't mean you have, it's been approved for use. It doesn't mean it's been, the patent office or it works, or that you're not infringing somebody else's IP. It's really just a right to stop people from doing what you've registered or have the IP on. It can be difficult to track IP. Startups are moving very fast. They're changing products. They're changing their product plan. There's a lot of different types of IP. I think most startups that I've seen that have been successful have some type of IP committee that meets regularly, maybe quarterly, to kind of talk about IP issues. What is our important IP? Let's write it down. Let's talk to an attorney, maybe on a quarterly basis, to keep track of these issues. If you do that early on, I think you're going to avoid problems later on. The other thing that we've seen is that ownership issues are common for startups. For copyrights and patents, ownership usually starts with the creator or the inventor. So it's very important for an IP to make sure you have all the agreements in place early on. If you're using a consultant, what does your consultant agreement say about who owns the IP? What does your employment agreement say about who owns the IP? These are things you should have, bounce off your attorney up front, make sure you have the right provisions in the agreements so that you own all the IP that's created by your company. I think we talked about this, understanding the IP and that of, what the different types of IP and what other people have a plan and know when to get legal help. Anything you wanted to kind of add, Damien?
Yeah, no. Like you said, it's important to make sure you own the IP and understand what other people have. Often people get tripped up thinking that, just because an employee develops something that you own it, but you need to check your employment agreements to make sure that they actually assign it to you. Similar with consultants, make sure that that you own the IP and not the consultant that owns the IP.
Okay. So we have a few final slides here. We wanted to end within 1 hour. And so I just wanted to kind of talk a little bit about, kind of reiterate some points, but in the terms of a product development pipeline, and then maybe answer some questions after that. So, you have an ideation process, you're forming a company. It's really early on. I think that's the time when you should be talking about to an IP attorney and probably thinking about IP. And some of the, when a company first come to me, here are some of the things that I'm having them kind of keep track of to kind of as the first steps to protect your IP. One thing is, I think it's very important to keep lab notebooks and to save and date prototypes. Used to be this was very important in the patent world to identify when you invented something, and that could help you get a patent application because it was the first to invent the system. But I think it's very important now to just keep track of ownership. Who came up with these ideas? If you're not keeping track of who developed this prototype, who had the idea to use this, that is the first step in determining who owns something, is determining who invented it. We mentioned that you want to secure ownership with strong employee contracts and consulting agreements. So that's one of the first steps you need to do as a startup. Damien mentioned potentially filing provisional patent applications early. And then to keep your trade secrets, you want to have internal trade secret agreements, policies in place, and make sure if you're talking to third parties that you have non-disclosure agreements in place. And so you should have non-disclosure agreements ready to go. Talk to your attorney about what type of non-disclosure agreements you want to use and have those things in order, the process set up very early on.
And you don't want to just file early, but you want to file early and often. Anytime you have an improvement to your idea or your product, you want to consider filing another provisional application. Anytime that you are going to have a presentation, consider putting your slides on file as a provisional patent application. You just want to make sure that you don't let something slip through, because as we talked about earlier, once you disclose, it impacts your ability to protect your invention, particularly internationally.
Okay. And then again, we keep mentioning IP ownership. This slide lists some of the agreements that can affect ownership rights. And so I just want to mention them so that you have your kind of paying attention to these agreements as they come up. But employment agreement, consulting agreement, development agreements, manufacturing agreements, collaboration agreements, visitor confidentiality agreements if somebody's visiting your office. These are all the types of agreements that you want to make sure have very strong confidentiality terms in them and terms about who owns the IP. The last bullet point there talks about government interest. If you're getting any type of government funding, a small business loan, an NIH grant, those also may give up rights to certain entities, or you may have certain licenses granted out. And so if you're getting any kind of investment like that from the government, that's something else you need to really carefully review the inventors on. If you are dealing with any university professor or anybody with ties to university, I think you need to be watch out and be careful then. Universities are notorious for having very strong IP provisions about anybody that works for them or any use of their facilities. So if you're involved with a university, you want to make sure you're really taking a look at those terms of those agreements.
So I see there's one question in here I want to answer about, provisional patent application as you improve your product. Yeah, I mean, we would recommend that. We understand that cost can sometimes be a factor. If you are just going to file your presentation before you give it, that is something you could consider doing yourself. The actual provisional patent application filing is relatively inexpensive. I mean, we generally would always recommend talking to an attorney first, just to make sure that you don't have some language that could harm you later. But, with a presentation, if you're going to describe something, if you're going to talk about it, you'd want to have that on file just to make sure that that doesn't count as a disclosure.
Yeah, and then I see some other questions in here. I think this might be a good place to probably end our presentation and maybe switch to some questions and answers. But there's a question about India and why is it not on the map? You can file a patent in India. The map that I showed was just an example of a foreign patent strategy. I have filed patent applications in India. They have a patent system. I think, though, the general consensus is people view Indian patents the way people view China patents maybe 20 years ago. That it's difficult to enforce patents in India, and it takes quite a long time to get enforcement in India. But that may change 5, 10, 15 years from now.
Yeah, that's right. And you want to consider, I mean, you might think you're going to sell your product worldwide, but think about whether you would actually enforce your patent in that country. I mean, it's terrible when someone knocks off your product, but if you sit down and think about it and you say, well, the market's very small, or I'm very unlikely to actually file a lawsuit there. Most of my product is maybe in the US, maybe in Europe, or I'm just not willing to spend the fees it's going to cost to litigate in a country, or the damages I'm going to get may be small. All information that you can discuss with an attorney. then you might think that it's just not worth filing in a particular country. And you may want to focus your budget on the countries that you are more likely to enforce your protection.
Yeah. And it depends on markets. I have a client that is in the aesthetics business, and that's one of the few clients that files in Brazil because they have a very active aesthetic industry and consumer base there. And so your industry may be very specific and may have maybe a need to file in a country that may not be in the normal suite of other countries that other companies might file. I think there's a question here about do I have to pay for a provisional patent application as I improve my product or as I improve my deck? So the way I'm interpreting that is, let me know if you disagree, Damien, but certainly as you improve your product and you're coming up with new technological inventions, I would be considering filing a provisional application each time those improvements come. The slide deck, I assume, is like a pitch deck, and that may not get into the technical details of each as you improve your product, is maybe doing the high level, the product, what the product does, the need, the market. And in those circumstances, a change of how you package your deck isn't disclosing any new technical innovation. And so it may not be necessary to update a provisional application in this situation. I'm often asked to review slide decks to make sure that if there's anything in there that is potentially, we're worried about getting out there, that we have filed for patent protection on those ideas before disclosing the information to an investor in these slide deck.
Right, and in particular, I mean, if you're considering presenting your slide deck for purposes of to other engineers to explain how it works, then it's important to file as a provisional, because then you might have the details in there of how your invention works. And I think there's a related question about, are my documents then public? So, I mean, if you're presenting a slide deck, then that could be considered public. If the question is referring to, is your provisional application public, then that answer would be no, until you file a regular application. And even then, that can be prevented from becoming public with a non-publication request. However, once it becomes a patent, then it will be published. Or if you want to file internationally, then you must let it publish.
Yeah, that's an important date. It's generally, the general rule is that 18 months after you file your application, which might be the provisional application, it will publish, unless, like as Damien said, there's some steps you take to not let that happen. So that's an important date to keep in mind, because that is when you're kind of letting people know that what you're doing, and the world's going to be able to look that up, and competitors are going to be able to look that up. And your patent applications tend to have a lot more technical detail than any other document that you're showing to people.
And so there's a question about how long can a non-provisional last, and what's a good way to extend the date. So a non-provisional patent gives you 20 years from the date of filing. That can be extended sometimes just a little bit based on delays by the patent office in examination. However, besides that, the non-provisional term can generally not be extended. If you have improvements to your product that you file later, which are inventive over your original filing, you may be able to protect those improvements still, but 20 years is what you get for the patent.
Yeah, and that's one of the reasons to continually file on improvements. The way your base patent may expire, but at least there may be a longer term on maybe the next generation improvements out there. That, well, it doesn't extend the term for all the technology, at least it does for certain portions of it. Then is there any other questions we missed, Damien? Or?
It looks like there's one. What if the name is similar to an existing trademark, but the company is currently in a different physical and product market. In the future, markets and products may combine. What then? So, I mean, this is one of the reasons why it's important to talk to a trademark attorney, is to consider what products you may go into in the future and to craft your description to cover not only your current products, but future products. And there is one requirement that you actually use the trademark in commerce for the different products you want to protect. So that is something to consider as to when you are going to release those products, or when you're going to start selling those products. And you may want to update your trademark filings as you consider new products. And certainly you'd want to also file in other countries where you'd want to enforce your trademark. I mean, there are instances where you could have the trademark in the US but not have it in Europe, and then there could be some conflicting or competing brands, which is another reason to do a search before you really settle on a particular brand or trademark.
So I see another question about what is the best source for finding attorneys that would consider contingency. So that question is for patent attorneys. I probably need a little bit more context on that. Certainly, there are contingency lawsuits. That is, if you're thinking about enforcing a patent against somebody else, there are law firms that will maybe take some lawsuits on a contingency fee case. And those are all lots of different types of firms out there will consider that. And I think you have to talk to an attorney about that, and they're going to have to make a choice on whether or not they believe that's a case they want to handle on a contingency fee basis. In terms of patent prosecution or filing patent applications or early kind of activity of a startup, most firms are going to operate on a fee-based system. There might be some firms that operate on a deferral system if they have strong ties to maybe the prior dealings with an inventor, or there are some firms that operate out there that may take equity in exchange for services for an early stage startup. Another thing I just want to mention, though, is there are some pro bono services that the USPTO, the U.S. Patent Office office now offers for individual inventors. If you just go to the United States Patent Office, so uspto.gov, and do some searching on that web page, they've been really trying to beef up the way to connect inventors with attorneys willing to work on a pro bono basis who on patent applications. And so that might be a way that you can get some help on filing a patent application if you don't have all the resources to file something. We often partner with universities, maybe law schools, to kind of help match up people for training purposes and inventors who can't afford a patent application. So any other kind of final questions?
No more questions? Anyone Q&A or in the chat? Hopefully Q&A. So all the questions been answered so far? I guess so. All right, Stephen, you can clear them or put them as answered. That would help. All right. Anybody would like to ask a question via a live audio? That would be great. Just raise your hand. All you need to do is raise your hand, and then we'll bring you in. So you said something I kind of didn't know, but it makes sense, is that if you do get, I don't know if Rabi or Damien said that, but if you do get a, maybe an SBIR or some kind of a grant, then it's out of the window, I guess, right? You can't protect it anymore?
No, you can get protection for it. There just may be conditions that the government may have on it in terms of their own use.
Okay.
It's not that you use it completely. It's just there are certain things that there's certain reporting obligations you may have. and you may have to give the government a license to use it for research purposes or for their own purposes.
Okay.
And if you don't follow certain steps, they may even assert ownership interest of it, and because you don't comply with the reporting requirements. So there's just little extra steps that you need to take to make sure you're in compliance with their requirements, basically. If you do that, you can still have your, get your money and protect your invention, but just be cognizant of those requirements.
Okay, so to follow up on that, you said something about if a professor at a university. So is that similar as well?
So again, each university kind of has different policies, but I think the sense is that universities over the last 10 years have been, have made a lot of revenue off of university inventions that their professors have created, and they are, many universities are reluctant to just give away the intellectual property developed by the professionals. So they often have tech transfer offices that you can work with and talk with up front to maybe negotiate if you're thinking about partnering with the university or a professor, and to work through those issues of the who owns the IP. So my suggestion is, if you're thinking about using a professor or partnering with a professor, just start thinking about those issues, talking to the tech transfer office early, make sure both sides understand who's going to own the IP. What we don't want to see is you just start working together, come up with a lot of great ideas, and then start talking about ownership. That's going to be too late.
That's interesting. So you're talking, that's when a university is commercializing something and a professor is involved. How about if it's the other way around? If you involve a professor in a, coming from the outside, and you involve the university, how does that work?
I mean, that again is going to depend on the university, but if they're using, for some universities, they believe that if you're using their facilities, their testing lab to come up with something, they own the IP. And if the professor, even though he may sign a consulting agreement with you, he may have an underlying employment agreement that says that the university owns all his inventions. So that's why I think you want to talk through these issues up front with the tech transfer department to make sure everybody's up and up. This is what we're planning to do. This is going to own it. Have them sign off on the relationship, I think, is the best course of action.
Okay. All right. All right. I think we have a couple of questions, but again, if anyone has any questions really that would like to come live, please raise your hand. This is from Lawrence again, if you want to read that, Damien or Rabi.
So it looks like it's just a statement. The DHS TSA has a Silicon Valley Innovation Center, and they're very aware of protecting ideas and patents.
Okay, yeah. And George says, how about discussing licensing a patent?
Yeah, so patents are often licensed. It's one of the things about a patent is that you can own it and you can divide up the rights and give people licenses. For example, if you have a technology that can be useful in a lot of different fields, you might give a license to one company in one field and a license to another company in another field. You can also give different types of licenses. You can give an exclusive license or a non-exclusive license to different companies.
Okay.
Or you may obtain an exclusive license or a non-exclusive license. You may also have a geographical license where you have the right to use a patent. If somebody has multiple patents, they may give you the right to exploit it in the United States, but not in Europe, for example.
Very interesting.
So,
okay.
Patents, that's why you often see patents involved with licenses a lot, is that it can be divided up in a lot of different ways. And there's a lot of different flavors of patent licenses.
Okay, all right. Okay, so I guess no more questions. So first, thank you all very much for doing this. This is, I learned a lot. So if I learned a lot, I'm sure a lot of people learned a lot as well. So thanks again. We're gonna jump to the virtual networking. So there is a link in the chat. Please grab the link. And there is a password. The password is Kenobi-2020-VIP. But grab the link to go there. Hopefully, Damien and Rabi could jump there too as well. If you use Chrome, it would be good if you're using your, somebody's not seeing the link. Can you send it over? Yeah. So if you use Chrome, it would connect better. If you don't, you can use your iPhone or Android app. You can download it and go there. So the setup is very quick. All you have to do is put your phone number and they'll let you in with a text. That's how easy that is. All right, so we'll jump off over there, and if you don't see a table that's open under the VIP section or the lounge section, VIP table section, I should say, just click on the plus sign and create your own table, and people can join you, or you can invite others. Thank you, Damien. Thank you, Robbie.
Appreciate everybody.
Thank you.
Have a great day.